Mitch, I have a question for you. I ran into somebody the other day and they were asking me what to do about a bank account. They said that they had already put their son on as a co-owner of that bank account. And then also they were talking about the land and things they own. They thought that was just the most simple way to go ahead and take care of it now. So could you please address that?
Well, Bambi, it is a simple solution. It is that it's quite simple, but there's a major problem with that plan, and unfortunately, I've seen that problem uh, come to light more than one time. And so, this is what people will tell me. They will say, "My son or my daughter is on my bank account, or they're on my deed with me, etc." So I'm not really sure what that means. So usually I ask, are they a co-owner? And sometimes they know and sometimes they don't, but they'll bring me a bank statement, maybe a signature card, and I can see, sure enough, they are a co-owner. And so if if you are a co-owner with your children of your account and a child gets divorced, a child becomes ill, which results maybe in a financial catastrophe, your money is now at risk because it's their money too. You gave it to them. And so their creditors, a hospital bill can take that money. A spouse can take that money in a divorce. I've seen people lose a few $100,000 in cash and CDs, their life savings, because they made a child a co-owner. Yeah, it was very simple. It's very easy. And had that child not become ill, had a giant hospital bill, everything would have been okay. But that didn't happen. There was, in this particular case, a very large debt to a hospital. The child was sued. Hospital took over $200,000. Another instance, a family placed a child's name on a farm. And at the time, that looked like a good thing to do. And a few years later, they put the child's name and the child's spouse's name on a deed. They became the owners of the farm. Their child was going to inherit the farm anyway. They thought, okay, well, that's fine. And so, they wished that would have waited till they died. But what happened was there was a divorce. The farm got sold and the money got divided because it was a gift to the child and the child's spouse. But even if you just give it to a child, that's still problematic. We don't want, nor do we need to transfer ownership of property directly into a child's name. It can work, and we all know people that it worked for. It's not been a problem, but it can be a huge risk. We do trust in those particular situations so that we don't lose property. We don't have to worry about divorces. We don't have to worry about financial catastrophes of children. We can protect property from those things. And so that's what we do. That's all we do all day long, every day. If you need help with this sort of thing, give the office of Mitch Cash a call, and Marshall, call 870-448-3600, and Harrison, call 870-704-4058. We can help.